responded to a court bid launched against its head, Advocate Busisiwe Mkwebane. The anti-corruption pressure group Accountability now approaching the North Gauteng High Court to seek an order that Mkhwebane is no longer fit to hold office, which ties into a process that's currently underway in Parliament. But also another story, a senior official in the Public Protector's Office in the Free State, Sphelo Samuel, who is the head of the Public Protector's Office in the Free State, saying that is the latest official to submit an affidavit in Parliament, becoming the most senior staff member in the Public Protector's administration to do so to date. Let's now bring in to this conversation the spokesperson of the office, Mr. Oupa Segalwe. A very good morning to you, Ndata Segalwe, and thank you for making the time this morning. Quite a few things to go through, but let's just confirm from you, the Public Protector, has she approached the courts asking for permission to be part of a process to reconfigure the State Capture Commission?
Well, thank you so much, Desiree, for the opportunity. That is not correct. The Deputy Chief Justice, Mr. Raymond Zondo, who is the chairperson of the Judicial Commission of Inquiry into State Capture, approached the court requesting it to extend the lifespan of that commission at least up to the end of this year, given the scope of work that he has before him. Now, in those papers, he cited the Public Protector as one of 8 respondents and interested parties in the matter, and presumably he did that because the Public Protector as an institution is the genesis of what we see as the State Capture Commission, because that commission is born out of a report of a Public Protector following an investigation into allegations of state capture. Yeah. And secondly, in that report of the Public Protector, the Public Protector, or the Office of the Public Protector, is given the responsibility to monitor the implementation of the remedial action in that particular report. So the commission, as it is actually, the implementation of that remedial action in action, as it were. So the Public Protector did not go to court to complain against the commission. In fact, she has said in her court papers that she will not oppose the application by the Deputy Chief Justice, and that she will abide with the outcome of the court process. But she went further to bring to the court's attention issues that were not covered in the founding affidavit. And among those issues is that this commission should not be allowed to go beyond 2020, because it will cost the people of South Africa a lot of money, in excess of R1 billion, and that is not ideal. But she is in support of what the Deputy Chief Justice seeks to achieve in this case, which is to say no more new issues should be brought into the process, as that will only serve to draw out this process and cost more.
So, besides the cost and the duration, what overall role does the Public Protector see herself playing in this process?
Well, the Public Protector in the court papers proposes that she, alongside the other interested parties, being the President and the Chairperson of the Commission, should work together to ensure that no more new issues are brought into this process, because that will only serve to draw out the process, as I've said, for more years before we can see finality, before we can see justice. But she is also cautioning that there are issues that have already been canvassed before the Commission, which ought not to have been reinvestigated, because when you look at the remedial action in the report of the previous Public Protector, it said that in paragraph 8.10 that law enforcement agencies ought to look into the evidence that is already contained in that report and move with it, hold people to account, and not have to wait for this current process to end. Otherwise, the more we delay this, the more justice is going to be delayed.
So we have a story here on our news and current affairs side where we sought comment from former Judge Johan Krichler. I'm going to ask our producers to put up a tweet where the public protector responds to this interview, saying that it's unfortunate that the SABC has brought on a retired judge to talk about things that they do not have full knowledge of, and saying that this results into a constitutional crisis. What does she mean? How does an interview become a constitutional crisis?
Well, clearly Judge Krichler is misinformed or is talking about things he doesn't know, because the public protector is not opposed to the application made by the Deputy Chief Justice. And the public protector did not take the commission to court. She was cited as a respondent, and that caused her to participate in that process because she is an interested party. I've already mentioned the fact that in the state capture report prepared by Advocate Madonsela, part of the remedial action is that the public protector should play an active role in monitoring implementation of the remedial action. And that commission itself is part and parcel of implementing that remedial action. So the public protector is not inserting herself where she is not required to. She's actually called upon to do that by the remedial action, and the Gauteng High Court has already said that that remedial action as it is appropriate.
So let's go back to this process that's taking place in Parliament. A senior official within your office, a provincial official, has come out to say there is abuse of finances within the Public Protector's office. How is the Public Protector responding to this?
Well, the Public Protector indicated yesterday that she's concerned about this latest trend among senior staff members who deposed to affidavits and sent those affidavits to Parliament so as to influence the process that Parliament is already embarking upon. Incidentally, those officials or staff members are doing that at a time when action is being taken against them or contemplated for unrelated cases of misconduct. And at this stage, the Public Protector has not ruled out the possibility that these staff members may be working with external parties with the hope that their disclosures will carry more weight since they come from within, as compared to criticism from people who are acting from outside the office. But be that as it may, the Public Protector is concerned that these staff members are talking about alleged cases of misconduct that took place many years ago, and all along they have kept quiet. Only when action is being taken against them do they come forward to make these disclosures, and she is of the view therefore that those disclosures are not being made in good faith. For instance, the latest staff members to do the latest staff member to do that, Mr. Samuel, is facing action after having been found guilty by a court of law for having assaulted a complainant who came to the Public Protector for help. And now that complainant is suing the office on the strength of that guilty verdict. When Mr. Samuel became aware that the Public Protector was about to act in relation to that, it's only then that he came forward with these allegations of misconduct and mismanagement of funds. And in terms of mismanagement of funds, he's referring to the fact that the Public Protector is involved in a lot of litigation. But he should know that the Public Protector does not just wake up and take people to court. People who are unhappy with her findings take her to court and cite her in the papers as a respondent. And that's when she gets involved in that litigation to defend her findings and also to protect the mandate of the office.
Why do you think there is a misunderstanding between the Public Protector's intentions in terms of the submissions she has made in terms of the reconfiguration of the State Capture Commission? Why is there a misunderstanding in terms of why she has done it and how it was done?
There's no misunderstanding. It's just a deliberate distortion by certain pockets of the media. I'm not sure to what end, but if people can just take time to read her affidavit, they will realize that there's no story there. The public protector has got no interest in destabilizing the commission. She supports the work of the commission and she wants to see that work finalized so that people can be held to account.
What's the latest in terms of communication between the public protector and the Speaker of the National Assembly? When the process started in Parliament, the public protector said the process was unconstitutional and unlawful, and sent through a letter to the National Assembly making a request to engage, a request that was spurned at that time by the National Assembly. What's the latest?
Well, there was that exchange of correspondence between the public protector and the speaker, and in the end, it did not amount to anything. In other words, the public protector was not successful in persuading the speaker to hold the process in abeyance until such time the issues that she has with the rules are addressed. And following that, the public protector launched a court bid, which is two-pronged. First and foremost, she seeks to have the current process that Parliament has embarked upon held in abeyance or interdicted until such time Part B of her application to court is addressed. And that is the issues of law and constitutionalism that she has with the rules as they are. She wants the court to pronounce on that so that the process can be fair going forward, because she is of the strong view that the rules as they are unfair to her, and therefore the entire process will be tainted and will be or will lack credibility.
Do you agree that much of the stories that we've been covering recently about the public protector have got absolutely nothing to do with the core business of the Chapter 9 institution? How has all of this impacted your work?
Well, all of these things are sideshows. The reality is that every single day we have investigators in the office, all hands on deck, doing the work that this institution was created to do. We have in excess of 14,000 cases in our caseload as we speak, and all of our 167 investigators spread across the country are working on those cases day in and day out, directly under the supervision of the public protector. So whatever happens in the media happens because maybe it will grab people's attention, it will sell newspapers, it will bring in more audiences. But for us, it's a side issue. We are focusing on the core mandate of the office, which is to investigate, report, and take appropriate remedial action where allegations and suspicions of improper conduct have been brought to the public protector's attention.
So the work of the public protector's office is going on as a matter of course?
It does. In fact, a week or two ago, the public protector held a press conference where she was releasing her findings in a number of matters, and those matters are the kind of issues that are normally not attractive to the media. She issued a report, for instance, about water problems in the Northwest Province, particularly in the Ngaka-Modiri-Molema district. She issued a report about land issues in Limpopo. She issued a report about procurement irregularities in the state involving the health department in KwaZulu-Natal and the South African Police Service. So work continues. Those reports, for instance, were not covered because there is this focus on these side issues that we are discussing now when we should be discussing the work of the office.
Finally, Oupa, I want to ask you something that is not really related, and it's not official, it's private, so you might not be able to answer. Recently, the public protector, Advocate Busisiwe Mkwebane, celebrated her 50th birthday, and pictures came out of that celebration, and in the room were several people, but one individual in attendance that created some questions was the attendance of former Minister Mkhwebane, who is the subject of an investigation in terms of the Vrede Dairy Farm. Does the public protector deem this appropriate behavior to be socializing with the person that she's investigating?
Well, the truth of the matter is that Mr. Mkhwebane was not on the guest list. In other words, he was not invited. It appears that he arrived at the venue in question in the company of a guest who had been invited. And there were about 250 guests in the house that evening. So the public protector would not have known who else is there, who was not supposed to be there, and so forth. So it's very mischievous of people to suggest that the public protector invited Mr. Zwane and was socializing with her. She didn't. He was not invited. He arrived in the company of a guest who had been invited, and the public protector had no way of knowing that. And even if she could have seen or became aware of his presence later on that evening, it's not clear if people really expected her to frog march him out of the building.
Thank you very much for talking to us this morning.
Thank you.